Welcome to the 2019 Ohio Center for Law-Related Education Moot Court Competition. I'm Chaba Sukos from the Ohio Supreme Court's Office of Public Information. We are about to watch two high school teams from across the state present oral arguments in front of a panel of judges arguing as appellants and appellees in a fictional court case. The purpose of moot court is to simulate the appellate court process, which is very different from the trial court process that many of you are familiar with. An appellate court hears appeals that come out of a lower court's decision. Appellate court cases are heard by a panel of judges instead of a single judge and jury. Attorneys in appellate cases do not interview witnesses or present evidence. Instead, appellate court proceedings consist of legal briefs and an oral argument. The case being argued before the moot court judges today is called Ozzy Mercury versus the state of Buckeye. When he's not touring, aspiring rocker Mercury lives alone in a motorhome he inherited from his mom. He parks it on a little-used public road behind an abandoned department store and takes advantage of some of the sewer, water, and electrical hookups. But since it's not the best area of town, Ozzy buys a pistol for protection. One day, he's practicing on his guitar and someone bangs on the door. He answers it, gun in hand, only to find it's the police. He narrowly avoids being shot by the surprised officer. However, he does not avoid being convicted of a felony for having a loaded firearm in a vehicle. Now, he's appealing. Mercury will argue that the particular characteristics of the pistol, how he possessed, and where he possessed it means he didn't actually violate the statute. Second, he's arguing that even if he did violate the statute as it's being applied to him in this case, violates his rights under the Second Amendment of the Constitution. Oral arguments for the 2019 moot court competition are about to begin at the Moyer Judicial Center in downtown Columbus. Let's take a look.
Before we begin, I'd like to have the members of the court introduce themselves, starting my far right.
My name is Tiffany Carwile. I'm with the Ohio Attorney General's Office in their Constitutional Offices section. I do both trial and appellate work and very excited to hear your arguments.
I'm Mike Hendershot. I'm also at the Attorney General's Office. I do primarily appellate litigation there.
Down at that end, far left.
My name is Ben Tracy. I'm a staff attorney on the 10th District Court of Appeals.
I am Melody Stewart, and I'm a justice here at the Ohio Supreme Court.
My name's Pat Fisher, and I do whatever she says. Not really. All right, we're ready to begin. Unless are we supposed to hear from you all on any introductions or anything? Or are you going to introduce yourself with each case?
We can, Your Honor.
Okay, please go ahead.
Good afternoon, Your Honors. My name is Faith Langdon, and my code will be E1. I will be representing the petitioner, Ozzy Mercury.
Thank you.
Good afternoon, Your Honors. My name is Calvin Huff. My student code is E2, and I will be presenting the constitutional argument for the petitioner.
Respondents?
Good afternoon, Your Honors. My name is Allie Nicolanus, and my student code is F3. I'm representing the statutory provision under the appellee.
Good afternoon, Your Honors. My name is Gwen Masha, and my student code is F4. I will be arguing the constitutionality for the appellee.
Welcome all to the Ohio Supreme Court. Let us begin, petitioner.
Yes, Your Honor. Before I begin, I would like to request to reserve 2 minutes for rebuttal from my co-counsel's time.
Grant.
May it please the court. The question the petitioner will be addressing today is whether the statute at hand, 2923.16b, applies to Mr. Mercury, and if so, whether Mr. Mercury violated this statute. The petitioner answers these questions in the negative. Today's issue involves no arcane nuances, only the simple definitions of a vehicle and a fastener. The first key issue we will address is establishing that Mr. Mercury's motorhome is in fact a residence rather than a motor vehicle. Under Buckeye Code 2923.16, a motor vehicle means every vehicle propelled or drawn by power other than muscular power or overhead electric trolley wires.
Sure sounds like the mobile home's a vehicle.
Well,
Isn't it propelled by an engine?
In Mr. Mercury's case, it is not, as it is not used at the time that this investigation was occurring.
It's capable of driving, though, right? It can be propelled.
Was the engine missing?
It is indeed capable of of being mobile, excuse me. However, if we turn to the case of, I believe it is State v. Hicks, the potential mobility of a manufactured home does not detract from its utility as a dwelling, which would therefore indicate that Mr. Mercury's motorhome was functioning as more of a home rather than a mobile vehicle.
Could Mr. Mercury have put the key in the ignition, turned it, and moved his home?
If he so wished to cause very intense damage to his home, he could. However, it is not an idea that he would.
Explain that. What do you mean if he wanted to cause intense damage to his home?
Well, as Mr. Mercury had created very robust utility connections after he turned the age of 18 as to make his residence more permanent, this would mean that the utilities were harder to disconnect, and if he tried to leave with them still connected, it would cause damage to his motorhome.
Wasn't the case that you cited, they had a foundation, so you couldn't actually move the vehicle, whereas in this case, he could undo the utilities and drive away. Isn't that correct?
That the case that State v. Hicks actually is about a smaller home that was at one point mobile, and even the mobility of that with the foundation and the permanently connected utilities,
These weren't permanently connected, you would agree?
they were semi-permanently connected. However,
So they weren't permanently connected.
they were more permanent than any basic RV would have.
Tell me what that means.
Well, most RV connections, as Mr. Mercury made his more robust, most RV connections would be much less permanent than Mr. Mercury purposefully made his.
Okay, but he could disconnect.
If he so wished to, yes.
Okay, so it can move.
If he so desired it to.
And he did do that. He would go and travel with his band and use the RV as his motor vehicle.
Yes, he would use it. However, if we looked to the case of Sylvester v. Howland Township Board of Zoning Appeals, it states that the nature of a proposed residence structure is determined based on the conditions existing at the situs. Now, if we look at the conditions that Mr. Mercury's motorhome was in at the time, we can see that it was being used as a home rather
Is
than
that
a
a case that you just cited? Is that interpreting the same statute? It sounds like it's a licensing case or something.
It is not the same statute. However, it could be applied to the case we are dealing with at hand.
How?
Well, it also speaks of proper sewing and plumbing and electrical facilities as being indications that a motorhome is a home. Although it doesn't deal with the same statute, it also deals with motorhomes and whether or not they can be determined to be residencies. And this case...
Are you saying if something was determined to be either a home or not under this licensing statute, that automatically imports over to the criminal code?
It does not, as this is merely a court of appeals case. It only holds persuasion over the court rather than complete precedence. So we can only look to this as a guidance as to what decision we make.
I have a question for you. Do you believe that the definition of motor vehicle under the statute is vague, such that we should even be talking about looking at case law to interpret it?
Well, the definition of motor vehicle in itself is not vague. However, the word vehicle that is included in that definition is not defined in the statute itself. Now, if we look at 2923.16, Division G, it states that the affirmative defenses authorized in Divisions D1 and 2 of Section 2923.12 of the Buckeye Code are affirmative defenses to a charge under Division B or C of this section that involves a firearm other than a handgun. Following Antonin Scalia's ordinary meaning canon, we can define handgun using its ordinary meaning. A handgun is a gun designed for use by one hand. And under this definition, Mr. Mercury's firearm cannot be considered to be a handgun.
Counsel, didn't he just say he never tried to use it with one hand? I mean, it's a very large gun, but it was designed as a one-handed gun, and it's just a little bit too large for him to. He was too scared to try it with one hand.
the original .44 caliber that this gun would be based on would be considered to be a handgun. However, the specific model that Mr. Mercury had included a longer barrel than the average .44 caliber, as well as a shoulder stock, which would more so indicate that it was closer to a shotgun rather
Does
than...
your argument depend on both of those things? Does it depend on both the longer than average barrel and this attachment that looks like a stock? Or is one of those sufficient, in your view, to take it outside of a handgun?
Well, if we look at the statute, it says that if it measures over 24 inches from the one end of the gun to the other, then it is not a handgun anymore. It's...
I don't know quite what that means. So I don't know the measurements of the individual pieces. My question is just, to take it outside of a handgun, as you're arguing, do I need to agree with you both about the barrel and about the stock for it to be outside the meaning of a handgun?
Yes, that would be correct, Your Honor.
Counselor, what would you designate Mr. Mercury's status at the time he encountered the police officer? Was he a passenger in the mobile home? Was he an inhabitant? Was he an operator for definition of 292316?
Well, he would be defined as more of an inhabitant, as this motorhome was not being used as a vehicle at the time that the police officer came upon him.
So he could not be an operator under these facts?
Under these facts, no. At the time, he was not an operator.
And he could not be a passenger under these facts?
No, as there was no operation of the motorhome taking place.
But in 292316 does not deal with any other status of a person other than an operator or passenger, correct?
I believe so, yes.
We would have to agree with you, though, first that the mobile home was a residence for him to be an occupant, because you could be sitting in a car, and you can have one person in the driver's seat and one person in the passenger seat, and it not be operating at the time, but still violate the statute.
Yes, however, assuming arguendo that it could be considered to be a motor vehicle, he still was not in violation of this statute, as he was using it for affirmative defense purposes, as defined under Buckeye Code 2923.12.
I'm not sure I follow. What do you mean he was using it for affirmative defense purposes?
He maintained the gun for purposes of self-defense, as Mr. Mercury lived in a very bad neighborhood and was in a fear of being robbed, which would justify him or any prudent person in going armed to defend himself.
So that would be a affirmative defense even if he was in a car?
Yes.
So he would be allowed to carry this gun in the passenger seat, widely open, with fully loaded?
No, the gun itself was not loaded. He would have to keep them separate and in containers that were provided separate.
But your view of the affirmative defense is, if it's a dangerous part of town, as I hear you saying, is it doesn't matter anything else about the gun. It could be fully loaded. It could be resting on his lap with his hand on the trigger, right? If the affirmative defense applies. I'm just trying to understand the scope of what you think the affirmative defense covers, right?
Well,
So
the
if he qualifies, it does not matter about where the magazine is, if it's in a separate container. Is that right?
Well, the affirmative defense covers the mere ownership of the gun, which is what Mr. Mercury owned it for. And as he did not have the gun loaded at the time, it wouldn't really be relevant as to whether or not the statute applies to whether it's loaded or otherwise.
Can you briefly talk about why your client's position about whether it was unloaded and whether that exception applies?
Do you mean whether or not he...
Whether there was it was in a separate container that had a fastener. Can you briefly discuss that point?
Well, with the term fastener that is included in the statute, it is not defined, but we can further turn to the ordinary meaning canon and define it as a device that closes or secures something as per its ordinary meaning, which would include Mr. Mercury's drawstring bag that he maintained his speed loader as well as his ammunition within. And he kept this drawstring bag containing the speed loader and the ammunition on his dashboard of his motorhome, while he kept the gun itself on a rack behind the driver's seat, which would constitute separate containment.
Does Petitioner concede that if somebody lived in a car and drove the car once in a while, say once a month, moved the location of the car, but they're too poor to own a home, and the same facts with the gun and the ammunition, that then that car would be operable and would be mobile.
Well, the difference in that case is that that car is driven more often than Mr. Mercury's motorhome. Mr. Mercury really only used his motorhome as a vehicle maybe once a year, which would be to visit his family around Christmas. Now, we must look back to...
So that's transportation.
Yes, it is.
So if somebody parked their car in a field and stayed there for a year, slept there, and then once a year drove it around to visit friends for the holidays, does Petitioner concede then that that car is mobile?
Well, as the car is not connected to any sort of utilities to form it into more of a home, it would not be considered to be a residence, more of still a motor vehicle.
So it's the connection.
Yes, Your Honor.
Okay, thank you.
Can a tent be a residence?
It could be considered a residence.
So it doesn't have to have any connections of any kind, right? Any utility hookups or anything? You're going completely off the grid in a tent. Is that a residence?
It could be considered a residence under the ordinary meaning of residence, but we must also look at how often it is used as a vehicle, and as well as if it's their only residence that they have opportunity to, if they own other homes or anything like that.
So whether something is a vehicle or a residence depends on what else the person owns?
Yes, as State v. Smith also would agree with this, as this case is about a truck driver who often sleeps in the sleeper portion of his semi-truck and maintained a loaded handgun as to prevent hijacking. The court upheld Smith's conviction as his truck did not constitute a home and was not entitled to a right of self-defense, as this wasn't his only residence. It was more of a pit stop, per se. It wasn't a residence.
Did Mr. Smith assert the affirmative defense the case discussed? Just the way you described the facts, he kept it to avoid being hijacked or robbed.
Yes, but the statute that we are dealing with also says that it must not be loaded and it must be kept separate, and the ammunition must be maintained in a container that provides complete and separate enclosure, as Mr. Mercury had.
And you can't avail yourself of the affirmative defense if it's a handgun, correct, counsel?
Yes, that is correct, Your Honor.
So what you're saying in this case is he only gets the affirmative defense if this long-barreled thing is not a handgun. Is that right?
That is correct, Your Honor. Now, Buckeye Code 2923.12 specifically says that affirmative defense is if the weapon was kept ready at hand by the actor for defensive purposes while the actor was engaged in lawful activity and had reasonable cause to fear a criminal attack upon the actor, such as would justify a prudent person in going armed. Now,
Well, he was stealing utilities, though, wasn't he? So is he engaged in lawful activity?
Well, the record is not clear as to whether or not Mr. Mercury had permission to be on the property. However, we can assume... I see I'm out of time. May I have a moment to briefly conclude?
Briefly.
For the preceding reasons, the petitioner asks that this court reverse and remand the lower court's opinion. Thank you.
Thank you. Proceed.
Good afternoon, Your Honors. Before my time begins, I would like to confirm that my student code is E2, and I will be presenting the constitutional argument for the petitioner. I will also remind the timekeepers in the bench that 2 minutes of my speaking time has been reserved for rebuttal at the end of the hearing.
I thought the rebuttal was reserved for her.
No, Your Honor. In my co-counsel statement, she outlined that it would be taken from my time, Your Honor, if that is permitted.
I don't think it is. Go ahead.
May it please the court. In this case, Mercury's actions are protected by the Second Amendment, and the relevant statute as applied to him is therefore unconstitutional.
Counselor, can you read the second, if you know it by heart, please say it, but if not, can you read what the Second Amendment to the U.S. Constitution says?
Your Honor, I do not have the Second Amendment memorized word for word to heart. However, it does guarantee the right of the people to bear arms.
Why, though?
For the purpose of a militia, Your Honor, however, in District of Columbia versus Heller, the landmark Supreme Court case, the United States Supreme Court, by a majority, held that the core purpose of the Second Amendment is actually to defend the right to self-defense, to protect oneself, Your Honor.
In all instances, so what do we do with the militia part of the Second Amendment, militia language?
Your Honor, upon reviewing centuries of case law and history, the United States Supreme Court, by a majority, did conclude that the use in a militia and the use for hunting are also uses that the Second Amendment was meant to protect. However, the right to self-defense is the central one, Your Honor.
And when we say bear arms, do we mean any kind of arms? Would you concede that in the days when the drafters of the constitutions and the constitutional amendments came about, there were no AK-57s or any assault rifles, but are they all bootstrapped into the protections of the Second Amendment?
Well, Your Honor, in District of Columbia versus Heller, the United States Supreme Court anticipated that sort of argument and laid out an exception that the Second Amendment right is not unlimited and dangerous and unusual weapons can, assuming a statute meets constitutional standards and review, restrict those dangerous and unusual weapons.
What about this weapon Mr. Mercury had? Was that anticipated by the drafters of the Second Amendment?
Your Honor, at the time of the Second Amendment, the drafters may not have considered the possibility of Mercury's weapon. However, looking at the court precedent that we have now and the decades of court precedent that we have, it is clear that Mercury's weapon would be protected under the Second Amendment.
What language or what case makes it so clear?
Your Honor, in District of Columbia versus Heller again, the United States Supreme Court held that any statute or restriction that would ban a common type of weapon from the home cannot uphold any standard of constitutional review.
But now,
Sorry to
but now we have a problem because you're talking about a home, but he was convicted for having this weapon in a motor vehicle. So is it a home or is it a vehicle?
Your Honor, this, at the time of the arrest, in the site of the arrest, Mercury's RV was a home. In California v. Carney, the United States Supreme Court gave us 5 factors in determining whether or not a vehicle is a home. Today, a few of those factors are not relevant, such as whether or not the vehicle had license plates, as we are not privy to whether or not that was the case as reported in the record. The 3 factors that are applicable today are, first, whether the home was attached to utilities, and it was. Mercury's motorhome was attached to water, power, and sewage utilities. And these were not just the typical RV utilities. As my co-counsel has mentioned, Mercury fortified and made these utilities more robust than the standard utility, and this indicates that Mercury was using his RV as a home.
What, did he pay utility bills, do you know?
Your Honor, the facts and the record reflect that Mercury was using utilities that were next to an abandoned Sears. The record does not reflect how Mercury paid for these utilities or if he did so. We are not, again, privy to those facts.
And not relevant for our determination?
Yes, Your Honor, that would be a separate hearing. The second standard and second factor from Carney that we can evaluate today is the ready mobility of a home at the turn of an ignition key. Mercury's motor home was not readily mobile at the turn of an ignition key. Again, Mercury's motor home was attached to 3 robust utility connections that he would have to alter and transform his vehicle before it could be used.
Do you have any constitutional argument if we disagree with you about it being a home? Because that seems to be very much overlaps with the statutory question, but say that as to the statutory question we disagree, do you have any constitutional argument if it was a vehicle?
Absolutely, Your Honor. Even if the court should find, assuming arguendo, that this motor home was indeed a vehicle, the respondent still has the burden to show that in this case the statute upheld a constitutional burden and met a standard of review. In determining what standard of review we would apply to this case, the bench is advised to turn to Perry Education Association versus Perry Local Educators Association. In that case, the United States Supreme Court differentiated statutes that would restrict the content of speech and statutes that would restrict the manner in which a person can deliver that speech.
Counselor, can you point to me where in the Buckeye Code it talks about ready mobility? That you and your co-counsel said this was being used as a home. The utilities were hardwired or hooked up in a way. It wasn't readily mobile. What relevance is that it wasn't readily mobile, and where can I find that in one of the Buckeye codes?
Yes, Your Honor. In the Buckeye Code, in determining what the definition of a vehicle is, the code directs us to a definition from a separate statute, and that definition defines a vehicle as any vehicle powered by et cetera, and that definition, Your Honors, is not very helpful. It is a circular definition that uses the term being defined in the definition itself. So in decoding this definition, the court must turn to California v. Carney and these other tests in determining what that vehicle would be, Your Honor.
So we got readily mobile from case law?
Yes, Your Honor, because the statute fails to provide an adequate definition of
We
that
have
term.
to decide that something's not a vehicle in order to apply Heller. That is, can something be a vehicle and notwithstanding being a vehicle also be a home within the meaning of Heller?
Your Honor, under District of Columbia versus Heller, it is not clear whether or not a vehicle could be given the same protections as a home. In Heller, the court just decided to use the word home specifically in describing that right.
And to back up a little bit still further, but still on the topic of Heller, Heller, I believe, and correct me if I'm wrong, says that you can have a handgun for self-defense in your home. Are you therefore conceding that his overlong pistol was a handgun? And does that not undermine what your colleague was previously arguing?
Your Honor, the facts of Heller do not merely point to handguns, but to common weapons in general. If a weapon can be shown to be commonly used, it would be unconstitutional for the Congress or the state to ban those weapons or order that they be kept inoperable. In determining what makes a common weapon, the Supreme Court in Heller laid out a few criteria that would make a weapon attractive to the general public. One of those would be being able to point a weapon with one hand. And Mercury, while not being able to fire the weapon with one hand, can certainly intimidate a potential intruder while operating it with one hand. Another criteria would be being able to carry it without requiring a superhuman upper body strength. And as an average high school student was able to carry this weapon, it seems that it also fulfilled this criteria. So in this sense, Mercury's weapon fulfills the criteria of a common weapon laid out by the United States Supreme Court in Heller and would be protected under that case law.
Can we conclude that Mercury's home/vehicle is a home for the meaning of the Second Amendment, even if it's not a home under the Buckeye statute? And if so, if we can split the atom that way, show me how to get there.
To repeat your question, Your Honor, you're asking if, even if the Buckeye Code would not include Mercury's home as a home.
Right, so under the statute, we conclude it's a vehicle. Can we conclude, for the purpose of the constitutional argument, that it doesn't matter what the statute says, that it is a constitutional home?
Yes, Your
Therefore,
Honor.
okay, and how do we get there?
Your Honor, again, turning to California v. Carney, even if the statute said that Mercury's RV was not a vehicle, the statute would be unconstitutional if the courts can show that it was indeed a vehicle. And again,
So are you saying Carney is about the Fourth Amendment? Is the meaning there the same as for the purposes of the Second Amendment? And if so, why?
yes, Your Honor, the precedent laid forth in California v. Carney can be readily applied to today's case. California v. Carney involved a question of privacy and the need for a warrant in that case. The core idea of the Fourth Amendment and of privacy is how a person treats a space and the sacred rights that they enjoy inside that curtilage. That directly parallels the way that Mercury would treat his home, and if he had privacy within that structure, it would also show that it was a home. So by showing that it would meet the Fourth Amendment criteria, it would also meet the Second Amendment criteria, if that makes sense.
Well, then
And
wouldn't this decision, and I think it's maybe Stevie Smith, come out differently? Because the truck driver considered the cab in his home. He kept a lot of personal items there. He slept there for the vast majority of the time. Food there. It was his home away from home. So if it's how you treat a place, then Smith would have been incorrect.
Well, Your Honor, a few factors from State v. Smith fail the Carney test and are thus differentiated from this case and show that Smith actually wasn't treating his semi-truck as a home. In State v. Smith, Smith's semi-truck was readily mobile at the turn of an ignition key. He was merely pulled out to the side of the road at a pit stop, and at a moment's notice, he could climb down from the sleeper cabin area, turn the ignition key, and drive away. Furthermore, Smith's semi-truck was not his only residence, and in this case, Ozzy Mercury's only residence, his last resort, his sanctum sanctorum, is his motorhome. And
Doesn't that suggest maybe the way that Smith was using his truck, that maybe a home for the purpose of the Second Amendment is broader than for the purpose of the Fourth?
Your Honor, would you repeat your question?
Sure, I'm just wondering if the purpose is self-defense, of where I'm sleeping and vulnerable, is it possible that the meaning of a home under the Second Amendment is actually broader than under the Fourth Amendment?
The definition of a home may very well be broader under the Second Amendment than the Fourth Amendment, but for the sake of being conservative and offering a credible argument that even the respondent side can agree to the premise.
So my question is incredible? I'm just teasing.
Counselor, you answered a question you answered a minute ago, or several seconds ago. So if Mr. Mercury had an apartment, a very small studio place in the nearby city, but the facts of this case were still the same with his RV or in the utilities, then you concede your case in its entirety?
Had Mercury been located in a small apartment, he would even more so, and it would be undeniable.
No, not located there. The facts are the same. He's in his RV, police officer comes, he gets his unloaded or loaded, depending on your legal definition, and comes to the door. But, you were comparing to State versus Smith, but he did have a small apartment in a nearby city, so it wasn't his only place of habitation. Does that change your legal analysis?
That would be definitely a fact to consider, Your Honor. Again, one of the 5 tests is how the home is being used as a residence, and in that circumstance, Mercury may or may not fail that test of the Carney test, but ultimately, we have to look at the 5 factors together, and those I still believe would indicate that Mercury was entitled to some rights in that scenario.
Counsel, do we even need to reach the constitutional question? Say we agreed with your colleague that the gun was unloaded per the statute because it was physically unloaded and the speed loader was in a separate container. Do we even need to go into whether the vehicle or not vehicle qualifies for protection under the Second Amendment?
To be frank, Your Honor, no. The respondent's burden is to prove both that this was not a home and that it was statutorily loaded. Should we prove either that he did not violate the statute or that his motor vehicle was a home, we would take this hearing, Your Honor. May I briefly conclude?
Please.
One quick question before you conclude. Which issue should we decide first? What's more important, the constitutional issue or the violation of the statute?
Your Honor, this is a very subjective question. Both questions would have to be answered together from the petitioner's perspective, and depending on how much we value the Second Amendment, that issue may be more important. However, both are important and both do prove that the petitioner was wrongfully convicted.
But if he went on the statutory claim, isn't the game over for the government?
If the petitioner would succeed in proving that Mercury did not violate the statute, the state would have no business here.
And then we wouldn't have to answer the second question.
Well, both questions are up for debate, Your Honor, and the petitioner would rather not face his conviction being upheld.
Thank you. Please finish.
For the preceding reasons, the petitioner asks that you reverse and remand the decision of the lower court. Thank you.
Thank you. Respondent? Oh. The court has ruled that E1 has 2 minutes left. So he has 2 more minutes? Okay, thank you. Thank you, that's fine.
Well, good afternoon again, Your Honors.
Do
Continue.
you have anything more to say? Just because you have the time, you don't have to use it, but.
No, I'm serious. Isn't it a fact that if we rule in favor of petitioners on the statute, we don't have to reach the constitutional requirement issue, and isn't that the way the law works?
Absolutely, Your Honor. If the defendant did not violate the statute and he was within the legal bounds of the statute, there is no need to address the constitutional issue. However, this has also arisen in the application of the government statute.
Absolutely.
Well, isn't it also courts are supposed to avoid constitutional issues if there's another way to resolve the case. So wouldn't we first want to resolve the statutory issue before reaching your issue?
Your Honor, I was brought onto this case by my firm after the decision about what points to argue was made, so I would not be able to answer that question, Your Honor.
Anything else?
No, Your Honors, for the preceding reasons, we still hold that the petitioner was correct in this instance and that the decision of the lower court should be reversed and remanded.
Thank you. Respondents? Please proceed.
Good afternoon, Chief Justice Fisher, Associate Justices. May it please the court. I, Code F3, along with my co-counsel, have the privilege of representing the appellee, the state of Buckeye. The words of a statute matter, and the words of this statute dictate that Mercury is liable under Buckeye Code 2923.16b. And during my time before this court, I will be addressing whether the lower court properly held that there is sufficient evidence to convict Mercury under this statute. It did.
Counselor, what was Mr. Mercury's status under 2923.16?
He was convicted under this statute?
No, what was his personal status as I read the statute? Was he an operator? Was he a passenger?
He was an operator of the vehicle, and he had a loaded speed loader within his
So what
vehicle.
was he doing to operate the vehicle?
He was an owner of the vehicle,
Right.
and he was within the vehicle.
Was owner part of the statute, 2923.16? Is owner a culpable state in the statute?
He was in a motor vehicle with a loaded firearm, which means that he is liable under the statute, whether or not he owned the motor vehicle. But yes, in this case, page 22 of the record indicates that this is his motor vehicle.
Well, it says, the statute says, no person shall knowingly, so no person, an individual, shall knowingly transport or have a loaded firearm in a motor vehicle in such a manner that the firearm is accessible to the operator or any passenger without leaving the vehicle. So what was Mr. Mercury?
Mr. Mercury was the person within the motor vehicle who had a readily accessible loaded firearm.
But
Was he?
Right, but
Go ahead.
You
Somebody
said-
else.
You said the language is very clear. So it says operator or passenger. No other status applies.
He operates the motor
So
vehicle.
you're saying Mr. Mercury was the operator who
Correct.
had access.
He couldn't just drive away, though.
He could easily drive away.
Right then. Instead of waiting and talking to people that they came to the door.
He was,
He would have had to disconnect things, right?
but the utility connections don't establish that it's not a motor vehicle. Because when we look to Ohio v. Hicks, the Ohio 4th District Court of Appeals ruled that utility connections don't make a motor home a residence. In fact, Hicks's mobile home had a sewage system attached to it and connected to the ground, but still the Ohio 4th District Court of Appeals ruled that his mobile home was in fact a motor vehicle. So just because it has utilities, as my opposing counsel mentioned, as their argument for why it was a residence, doesn't actually make it a residence.
But the officer knocked on the door. He answered. He couldn't have, instead of answering, put his key in the vehicle or the motor home and driven off. He couldn't have done that, could he have?
He could have driven off while he was attached. It might have caused harm to the vehicle and the building, but theoretically he could still put his keys in the ignition and drive away.
How can he do that and answer the door?
He can open the door and then get into the driver's seat and drive away, but regardless, the statute says that to have a loaded firearm within a motor vehicle makes you liable under the statute. Indeed, he does have a loaded firearm
Makes you
within a motor
liable under the statute only if it's accessible to the operator or the passenger.
It is accessible to the operator and passenger because he doesn't have to leave the car in order to grab it.
Was he both? Or he owned the thing, right?
Yes.
I think Justice Stewart's asking a good question. Was he an operator? Was he a passenger? Was he neither? Was he both?
I would say he's both because
How can you be an operator and a passenger at the same time?
he operates the motor vehicle, so he is in fact an operator.
So he's an operator?
Yes.
Okay.
Well, now that brings me another question. How do we know he's the operator? Did we see him move the vehicle? What if his buddy Joe drove it there and he hasn't operated it other than hooking up the utilities?
Well, on page 23 of the record, it indicates that he uses his motorhome as transportation to tour for his rock band.
But do you think the word operator under the statute means ever operated or currently operating at the time?
It likely means currently operating at the time.
Good answer.
And because he was within that vehicle and because it was his vehicle that he could have operated with his loaded firearm within it, he is still liable under the statute.
But he could have operated,
But
not
he
that he
wasn't.
was operating, though.
He was within his motor vehicle.
But is that operating?
Because-
Under the statute, under the rational meaning of improperly handling firearms in a motor vehicle, could he be deemed an operator when he goes to the door and opens it for the police officer?
He cannot be deemed an operator when he opens the door. But still, he does have this loaded gun within his motor vehicle.
So you're going to say he's a passenger now?
He's in his motor vehicle, but he's not driving it. So yes, under that interpretation, he's a passenger.
Do you agree he has to be one or the other? There's no third status he can be, right, and be convicted under this statute?
Correct.
Okay.
Let me ask a question, counsel. Does he have to be one or the other? That is, does there have to be an actual operator or passenger? Because as I read the statute, it says accessible to an operator or passenger.
Yes, he was an operator of the vehicle, and it was accessible to him, so he is still liable under the statute. And his gun is loaded. Because Mercury had a loaded speed
I want to go back to the operation. What were the keys in the ignition?
The record is silent on that, but because it is in park, it would be assumed that the keys are not in the ignition.
Okay, so the keys aren't in the ignition. How can he be operating the vehicle?
He is within the vehicle, and he owns the vehicle, and he has a loaded firearm within the vehicle. He could easily get into the driver's seat and drive away.
But you said before he's an operator.
He is an operator.
But if
That
the
doesn't mean
key-
he's
but-
operating it at that moment.
Well, if the key's not in the ignition, how can he operate the vehicle?
By putting the keys in the ignition.
Okay, and you said there's no evidence put on by the state that there were keys in the ignition or where they were or anything, right?
Well, he does have keys to the vehicle that he can put in the ignition and then drive away, so that still makes him an operator of the vehicle because he has the potential to be an operator of the vehicle.
Could he be an owner, non-operator of a vehicle?
Yes, you could own a vehicle but then never drive it, but because he has no family members within his motorhome, and he was abandoned by his family, then it can be reasonably inferred that he owns it and operates
So
it.
he's an orphan owner operator.
Yes, he is an orphan
Owner
owner.
operator.
Yes.
The three continue.
So in today's case, Mercury's speed loader was not in a container. His loaded speed loader was not in a container as the statute requires. The drawstring bag in which the loaded speed loader was enclosed, as page 24 of the record indicates, does not meet the qualifications of a container because it is just a loose covering.
Counsel,
Oh, go ahead.
you started off today saying that words of a statute matter. The statute says a container. A bag is a container. It says you need a fastener. Pulling together strings fastens the bag. So why is that not a container with a fastener?
Well, within the words of the statute, it gives examples of what a container is. It says that a container is a package, a box, or a case.
It says, but not limited to, doesn't it?
It says, but not limited to. But when you look to Perrysburg Township, the Ohio Supreme Court ruled that lists and definitions are substantial and not surplusage. So when you're looking at the lists given, you have to be able to interpret what is given in order to understand what is included in that list, but what it's not limited to. And the common characteristic that a package, a box, and a case share is being a hard divider between an object and its surroundings.
Package is, I think of a package as what I might open on Christmas morning or something, right? It's just covered in paper. So why is that not also a bag with a drawstring on it?
It is not a bag with a drawstring on it because just a simple package in which you open on Christmas, it could be a stocking, correct? Well, if it's just a...
You tell me.
If it's just a stocking with something in it, you wouldn't transport and carry a loaded speed loader and just a simple covering like a stocking. In fact, it also has to be closed. And when
I'm just trying to build off the word package is in the statute, right?
correct.
Okay. And so to understand the meaning of the drawstring bag, we should get our minds around what a package is. So what does package mean in the statute?
A package can be a hard divider between an object and its surroundings. That's a common characteristic.
That's what I
in
wanted to ask about the
whole
word hard. You keep using the word hard. If I have a old used bank deposit bag that I have to lock, it's got strings just like a drawstring, but you lock it so that those can't be opened until the bank opens the deposit the next morning. Is that a package?
It is not a package.
Because it's not hard? That's what makes it a package, is the hardness?
It could be considered a package, but because it has that lock on it and that secured fastener, then that means that it is a container under this definition. But it doesn't.
Well, wait. It doesn't. It's not a box. What were the three in the statute?
A package, a box, or a case.
Oh, it's not a package. It's not a box. It's not a case.
Well, if
It's a bag.
Well, then in that case, it doesn't fall under the statute, because if the legislature wanted a drawstring bag or any bag for
Wait,
that matter.
if I keep my speed loader in a locked, two-keyed bag, where Justice Fisher and I have to both put our keys in to open it, that doesn't count?
Well, it doesn't list bag within the statute. So if the legislature wanted a bag of any sort to be included, they had the discretion to carve that out within the language of the
So you're
statute.
saying package is where you get this hardness requirement?
Correct.
But you can go and mail something and put it in a package that isn't hard. They have large mail envelopes at the post office. You put it in, you seal it, and you mail it. And it's a package. You have to pay a lot more for it than you do a normal envelope.
And you ever try to open some of those things sometimes too? They're hard to open.
You wouldn't have a company or an individual wouldn't ship a loaded speed loader within just a simple paper bag or a package that you'd pick up from USPS that is like the one you're describing. So that's the difference between a package under the statute in the context.
What's the definition of package? Do you have a statute? Do you have a definition from a dictionary?
The general definition of a container is a covering that holds.
No, package. Do you have the dictionary definition of package?
I do not have the dictionary definition of package with me. But when we look at the fact that a container is limited to it includes but is not limited to a package, a box, or a case, the shared characteristics between those means that a bag does not apply. And this distinction proves that the level of coverage that a bag provides is not comparable to that a box provides. And to conclude that the drawstring bag was an appropriate container would be to say that both a box and a bag provide equal coverage, which they do not.
What's the purpose of the having? I'm sorry.
All right. I mean, you can't load a gun with the speed loader while it's in the bag, right? And I mean, isn't that, if you know, without being hyper technical about the statute, isn't that what the statute's aiming at?
The statute's aiming at not having something readily accessible, and because the
Right, so you got to take it out of the bag first. You got to undo the drawstring, take it out of the bag, and then you get to load your gun, and not before. So how does that not accomplish all the necessary things that the statute wants to accomplish, and indicates that it wants to accomplish by using the language not exclusive to these three things?
The fasteners that are outlined within the statute don't include just a drawstring bag, the mechanism which in that. It includes a buttoning or a zipping or things of that nature.
You're saying that a drawstring doing this motion is different than this motion for a zipper? All you just do is pull it open for a drawstring, or you go down for a zipper. How is that any different?
There's nothing secure about the looping mechanism within a drawstring bag. Even if it's closed, you can still reach your hand within the hole that remains and still grab something out of it. Any movement at all opens up a drawstring bag further, whereas with a zipper, if it's zipped, you can't do anything about it unless you pull down. And so because the speed loader was not in a separate container, his gun is loaded, so he is liable under the statute. But next, his motor home was a motor vehicle. So Chief Justice Fisher asked the opposing counsel if, because the engine worked in the motor home, if it was a motor vehicle. And to answer your question, Chief Justice Fisher, because it had an engine working, and because it had wheels, and because it was easily driven, it was readily mobile. And in California,
What if the battery were dead?
if the battery was dead, it would not be a motor vehicle because it could not be driven away.
Do you know, is there any evidence in the record that the battery was operable?
There is no evidence within the record that the battery is operable, but however, because this is his sole form of transportation, then it can be reasonably concluded that he can't just sit behind the Sears parking lot forever, that his battery has to work.
Isn't the standard beyond a reasonable doubt, not just reasonably concluded?
Yes, Your Honor.
And actually, if he's been sitting there for too long and the weather's bad, the battery might have died. He might have needed a jump.
That may be true, but because the record is silent on that issue, that cannot be reasonably concluded. Furthermore, when you look to California v. Carney, the U.S. Supreme Court ruled that if the vehicle in question is readily mobile, then it is a motor vehicle. And because this motorhome is readily mobile, it is a motor vehicle. And for these reasons, we respectfully request that this court uphold the decision of the lower court.
Thank you. Please proceed.
Hey, where's she going? Come back.
Okay.
Please proceed.
Good afternoon, Chief Justice Fisher, Associate Justices. May it please the court. I, Code F4, along with my co-counsel, have the privilege of representing the appellee, the state of Buckeye. The right to bear arms is not without fundamental limitations. In my time before the court, I will be addressing the second issue of whether the lower court properly held that the Second Amendment does not protect Ozzy Mercury. It did. Your Honors, we respectfully request that this court uphold the decision of the lower court for the following two reasons. First, Ozzy's conviction under the statute was constitutional, and two, Ozzy Mercury is not protected under the Second Amendment because his mobile home is a residence. The Second Amendment provides that a
Are you using for that the statutory meaning of residence, or like I discussed with your friends over here, the Constitution and the statute have different criteria for what constitutes a residence?
In addition to what my co-counsel has stated, I will be addressing California v. Carney as a way to determine whether or not a mobile home is a residence, as that case does specifically carve out the difference.
Sorry, the difference between a statute and the Constitution, or
The
some
difference
other
between
difference?
a mobile home and a residence.
And that was for Fourth Amendment purposes, correct?
It was, but because it does dictate the difference, we can look to it and see the difference.
Are you saying that the definition of a residence for Second Amendment purposes is the same for Fourth Amendment purposes?
Yes. The Second Amendment provides that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. The Second Amendment has been interpreted as an individual right, including the inherent right of self-defense, which was recognized in Heller. Further, City of Chicago v. McDonald upholded the statement and included the states. In addition, the right to bear arms is not without limitations. In order to see why appellant's conviction under the statute is constitutional, this court must look to the standards of intermediate scrutiny. Perry Education Association and U.S. v. Macy-Nodaro both come to the conclusion that two questions must be answered when regulating legislation that regulates the Second Amendment. One, is such legislation narrowly tailored to serve a significant government interest? And two, does that legislation leave an open alternative means of exercising that right? In the case—
Tell me where this maybe syllogism goes wrong. The point of the Second Amendment as an individual right is self-defense. And if I have nowhere else to go, where I'm most vulnerable, where I'm sleeping at night, that's where I most need self-defense. That's where Mr. Mercury was. Ergo, the Second Amendment protects him there.
Well, appellant has alternate means to exercise his right because he simply could have just walked outside of his vehicle. But in addition, appellant is not granted the unlimited—
Wait, so if he should have rushed out past the police and then brandish his gun, then he's fine?
Well, there's multiple ways that appellant has the means to exercise his right. One way is outside of his vehicle, considering it is it's an open carry state.
How could he have carried? I mean, where would he have put it? I mean, it would be in his vehicle. I mean, he had no other place to put the handgun. So where would he have put it to be able to exercise it outside of the motorhome?
Well, while he is outside of it, but while he is inside of it, he has the responsibility of following the established limitations in the statute. An appellant is not granted the unlimited use to use his firearm for any point at any given time.
Well, he didn't use it, did he?
No.
So you're saying that because he met the officer at the door with the weapon in hand, he violated the statute, the government has a right to impose limitations on that use, and therefore his rights were not violated.
Yes, the government.
Okay, so if the gun were sitting on his table, would he have violated the statute?
Yes, he still would have violated the statute.
But would his Second Amendment rights be violated by the state?
They're not violated, but they have a valid limitation in order to protect public safety and the safety of the police officer.
But you're saying if the weapon was on the table, you're saying he could not, you're saying he had a right to have it on the table. It was in his home/mobile unit, but because he had the gun in hand?
No, not specifically.
Okay.
Appellant still has to follow the statutory confinement of an enclosed and separate container.
Wasn't that exactly what Heller, DC had? You could have a handgun, but there was numerous restrictions on how you had to keep that handgun in your home. One of them being unloaded. The same here. So, if this is what he uses as his residence, he wanted self-defense because, as my justice said, that's where he felt vulnerable. How is this different than Heller?
Because in the case of Ozzy, he is in a vehicle, and in vehicles, there is a respect to safety, not only for the public, but for police officers, and because a police officer needs to have that expectation.
Well, let me stop you there, counsel. I mean, guns are dangerous, right? And public safety is obviously a legitimate concern for the state, and officer safety and so on. But the state still can't, because we have the Second Amendment, outright ban all handguns. So why is this restriction okay? I mean, public safety, fine, we grant, that's an important interest, but what separate interest above and beyond general public safety makes this particular restriction okay?
This restriction is okay because we need to consider the safety of the police officer and the difference between what constitutes the rights of appellant in a home versus a vehicle. In a home, an officer has the understanding, as it is an open carry state, that a person can open the door with a gun in their hand. And the officer understands that and it plans accordingly for situations like that. But in a vehicle, it's different because the officer needs that certainty that he will not have a window rolled down right in front of him and have a loaded gun pointed at him. Because if that was the case,
Didn't he knock on the door like he would a normal house, though? I mean, there's a door that he could knock on. There were normal type of windows that just don't roll down at a push of a button like a vehicle. Isn't the characteristics of a mobile home more like a actual home?
Well, not necessarily, because mobile homes have a duality purpose. And understanding the door, that's the only really opening to a mobile home. And that's the reason why the officer knocked on the door is because he didn't have any other choice. There isn't necessarily, especially in the picture.
There are windows.
There are windows, but usually the officer does go up to the door. And in this case, that's the only option he really had.
So he went up to a door that's like a home. And you just said there's a dual purpose to a motor home. So for Second Amendment purposes, why shouldn't we find that this is a home versus a motor vehicle, since that was how he was using it at the time?
In order to understand why we shouldn't find it as a home, we can look to California v. Carney. And in California v. Carney, they found that the expectation of privacy with respect to one's automobile is significantly less than relating to one's home or office. And they also stated that among the factors that might be relevant in determining whether a warrant would be required is its location and whether it has convenient access to a public road. Appellant's motorhome has a reduced expectation of rights because it is mobile and is
Would you
not...
say that Ozzy has a reduced expectation of privacy under the Fourth Amendment? Could the police have gone in without a warrant?
Well, he has a reduced expectation of rights and privacy, considering the fact that it is an automobile. So yes, the police have a right to do that when it is a mobile vehicle.
So for the purpose of the Fourth Amendment, like in Carney, they would not have needed a warrant.
No. Appellant parked his motorhome. If appellant had parked his motorhome in a paid community of lots, our situation would be different. But appellant is parked in a parking lot.
Well, what's the difference? What changes the character of him, his status, and the vehicle/home?
If he was parked in a community of mobile homes, he would be situated in a place where he is meant to be there. The government is recognizing that he is allowed to be there, and he pays property taxes to be there. In this situation,
Isn't his need for defense greater where he's parked than if he's in, Sunny Acres somewhere in Yuma where he has all these neighbors? This seems like the purpose of the Second Amendment is self-defense. That seems to be at its apex here.
while it is unfortunate that Ozzy Mercury is in a situation where he is in a bad neighborhood, he still has the responsibility of following the established limitations. And Ozzy Mercury could have gone to a mobile home community. It's not, and
He couldn't afford it.
well, where he is right now is most likely a commercially zoned area because of the fact that it's a Sears building. And that's not a residential area where Ozzy Mercury should be located.
Why do protections under the Second Amendment ebb and flow with where your motorhome goes?
Because in the case of a community of mobile homes, if he is there and he is stationary, it can be concluded, it's very clear that that is his home. That's where he pays to be.
Well, would you still, then he would not be in violation of the statute?
If he was parked in a place where he paid property taxes and he was situated
What
there,
if he was just renting, and so he wasn't paying property taxes? Where in the Second Amendment or any case law does it say you have to pay property taxes in order to have your rights?
it doesn't specifically state that, but it is concluded that it has to be a home. And when we look at the characteristics of what people consider a home, paying property taxes and being in a place where homes generally are is something to consider here.
Well, but we would look at 29, 23, and I know that's your co-counsel's argument, but it doesn't talk about being in a mobile home lot, or it doesn't talk about paying rent, or paying for space, or paying rental, or paying property taxes. So you're saying if he were in that situation, if his vehicle was located not behind the Sears, but in a mobile home lot, he would not be in violation of 292316.
Our situation would be different, yes.
He
Just
would not-
based on
he would-
location.
It is it is another factor, yes.
But that doesn't change the readily mobile nature of it, doesn't change whether he's an operator or a passenger, doesn't change the whether it's in a container or a bag.
Well, it is in addition to multiple different factors. Carney did state that this is just one other instance of how it can be differentiated from a motor vehicle and a home.
Well, help me with this puzzle. It seems like, as one of the statutes about self-defense recognizes, you yourself said the Second Amendment is about defense. And as that statute recognizes the need for that defense may go up in situations where you have fewer resources. So how are we supposed to, in your view, view the Second Amendment as being, it seems like it's inversely related to my wealth?
Not necessarily, because this specific situation is about a motor vehicle, and that is the most important consideration because of the fact that motor vehicles have a nature that allows them to leave a crime scene before they are even caught, or have drive-by shootings, or potentially hurt an officer. That is the most important consideration here when we are looking at the Second Amendment. And when we look at that, we understand that limitations are in fact valid, and it's not necessarily just, I can protect myself. The government also has to consider that there is other people who need to be protected, and it's not an inherent right. It's an inherent right that also has limitations.
So you're saying that the extra interest in protecting people from gun violence from mobile vehicles is what justifies this law. Fine. But, I mean, didn't Carney say some stuff about electrical hookups, et cetera? I mean, why is this under Carney definitely a vehicle and not a home?
This is most definitely a vehicle because of the fact that the location and the fact that it is more readily mobile. The location is specifically important in this case because of the fact that it was in a place that most likely is commercially zoned. You would likely never see a mobile home parked in a parking lot and consider the fact that it is a residence. A parking lot is a place where people temporarily go in order to get to a location. It's not a residence. It's not somewhere where the government says, okay, that's where you can live permanently.
But
So-
as Justice Fisher pointed out, doesn't the countervailing interest in Second Amendment protections grow in commensurate importance at that point? I mean, because he's in such a dangerous area, he all the more is justified in protecting himself.
He is in a dangerous area, but like I said before, that doesn't exclude him from the statute. He still has the responsibility of following the limitations in order to, because of this government interest, which is public safety of the people, public safety of the officer. It is unfortunate that Ozzy Mercury is in a bad neighborhood, but that doesn't constitute him from being able to use his rights compared to someone else.
Counsel.
Would he have been okay if he had the gun in a box? Officer knocks on the door. This is kind of a follow-up on Justice Hendershot's question. He walks outside, opens the box, and draws the gun.
It would be a different situation then, yes, because he is not in his motor vehicle and it is an open carry state. If he felt threatened enough where he needed to use his gun, then in that case, yes, it would be constitutional.
Did he know it was the police when they knocked?
He wasn't sure about who it was because he heard an inaudible sound.
If we think that both sides are roughly even about the definition of a motor vehicle, and in this being a criminal case, who do we give deference to interpretation of the statute, the states or the defendants?
But please answer the question.
Okay. Well, all evidence must be viewed in favor of the government, but or in favor of the appellant. But we have the state does in fact. It is not our burden specifically. And for these reasons, we respectfully request that this court uphold the decision of the lower court.
Thank you.
Good afternoon, Your Honors, and may it please the court. In closing, the petitioner would like to return to the definition of fastener. Using Antonin Scalia's mode of interpretation of associated words canon, we must look at the list of words included around the word fastener, and some of those are a snap, button, buckle, or hook and loop mechanism. And looking at those and finding the similarities between all of those definitions of a complete and separate enclosure, it is clear that a drawstring bag would be included. A snap and a button, those are not airtight seals and would not, as Respondent has claimed, make the drawstring bag not an enclosure. And finally, Your Honor, the rule of lenity, another canon of interpretation, rules in favor of the petitioner in the definition of terms that are left unclear. Thank you, Your Honor.
Thank you.
I want to say congratulations to both teams.
You put in a lot of work and it showed. You did that, and you persevered under grueling questioning, and I can tell you got a little frustrated, and that's real life. I got frustrated and I've done oral arguments. So good job at continuing to answer the questions and in keeping your poise and confidence. And just congratulations on the job well done.
Yeah, let me echo that. I mean, one thing I think this whole exercise tests is the ability, you're trying to do several things at once. You're trying to analyze what concerns several of us have at once. You're trying to answer those and trying to think under pressure. You know, the rebuttal, I don't really want you to do that. That's really the acid test for that. What do you need to latch on to and say, try to move or vote one way or the other. So I really applaud all of you for doing that. I hope you asked the question. Enjoy it. Yeah.
This argument was just spectacular. I thought you all did so incredibly well. One of the things that was very much on the mind of the case committee when we wrote the scenario was throwing a lot of potential arguments into the fact pattern and making you make strategic judgments about what things you would emphasize and what things you actually abandon. And it's never shameful, I think, in an argument if you're challenged on something and you know you're weak on that point, but you win on something else, to say, okay, Your Honor, we'll grant that that's the case, but still, here's why I win another way. And then you don't have to get bogged down by questions that can take up the bulk of your argument and not do you any favors. And I think that's important to keep in mind. So that would be my one critique, but wow, you guys were terrific. So.
I echo that. I have a couple of just detailed things. Faith. So Faith, when you had a softball tournament at one point that I was hoping you'd hit out of the park. And we were talking about operator, vehicle, passenger, etc. And I was waiting for you to say, yeah, but he wasn't sitting in the driver's seat. And he wasn't a passenger. He couldn't, that's not what the statute contemplated. It's for officer safety when they're passenger in the seat and it's in the confines of the car, the officer can't see it. So I was hoping you get that, but you answered the questions well. Good use of case law. Be careful. You tend to focus on the judge who's answering the question as opposed to give all of us eye contact. But otherwise, you knew the fact pattern obviously very well in the case law. Calvin, you had good eye contact with the judges. You handled well the not readily mobile case. You like that Heller case. It's good for you to use it. He had a good rapport with the bench. And good answers on interpretation of the Second Amendment, and I really was trying to take you down a militia trail. But you did well. Allie, I think we were harder on you. We were just bombarding. Oh, your co-counsel agreed. You beat up on Allie. We're sorry if it felt like that. But you handled it very well, and you gave us good eye contact. And you were, those facts were, it seems like you felt like you had to have an answer for your client. Didn't matter what we thought or what we thought about it, and that you needed to paint them so they were. It's sometimes okay to concede something as long as you don't concede your case, but you handled yourself well. And Gwen, so you stood up there, and I think you said, take a breath, don't be nervous. And first I thought you were leaving when you went around the pillar. I'm glad you stayed. But you two had a good use of case law. Be careful. I think you referred to Ozzy Mercury once as Ozzy. And you want to be careful because you want to stay respectful of the other side, another defendant. There are times, of course, the states just going to want to depersonalize and just call him the defendant, which that would be totally appropriate from your hat. But if you're going to refer to him by name, then use the assert pronouns at times. But you all did a great job. Nothing left for you, Punchy.
No, I got nothing left except I have to say this was the hottest bench I've seen at this moot court. Moot court, really. And if you ever want to be an appellate advocate, I recommend you go on our website and you find one where Mr. Hendershot is arguing. He's got good pacing, very knowledgeable, doesn't lose control. And I want to say the two statutory arguments. We hit you harder than people get hit in the Ohio Supreme Court. And you both held up very well. Very well. But all four of you should be very well. But you two, we bombarded. I know there's a TV show, Hot Bench. I haven't seen it. But we were on fire. And it's hard because if there's a 3-judge panel, it's easy because you don't have to look all the way up and down the line. But just know that looking just at the person asking the question, that's fine, as long as after you're done answering, you go back to look at everybody else. Or as you're answering, look at all of them. I was very proud of all there. Several years ago, came to OCLRE and pushed for us to have the court as well as one trial. You guys are, wow. You guys are the best, no matter what happens. You really are. Very proud. If you all get your law degree someday and need a job, I won't be in office, but you can call. I'll be too old to be in office. But really, this of the 6 years I've been here, I think 5 of the 6, this was the best argument by far because it was so intense from here. And so I don't want you to, when you sat down, you're like, oh, thank God that's over. And then I've screwed you guys up with the rebuttal thing. But I think somebody misled me about the local rules. But we'll find out about that afterwards. Anyway, but you handled it. Okay? That happens in court. Judges screw up on something small, but it affects you hugely. You've got to just live with it and work within what the judge is saying. And you all did. And that's very good. So a lot of law students don't know that. So I guess we're waiting for some results. But thank you all for participating, and everybody else who helped, coaches, parents, everybody else. It's a lot of time, it's a lot of effort, but it's a great program, and especially today's argument. Thank you.
We don't even know. I'm nervous.
And so, Justice Fisher, Justice Stewart, if you wouldn't mind, would you help pass out the trophies to our teams
Pleasure.
as well?
Sure.
We have two extremely talented teams in front of us today, and both did extremely well all day. So, as we announced these final placements, if the entire team and the advisors will come up to receive their awards as we crown our champion for the 2019 Moot Court competition. State champion this year, congratulations to Danville High School, who is Team E. Congratulations, guys.
Like baseball, there's no crying. There you go. Please put these on. I guess you are. You're going to have to turn around. Face these people. There you go. Go over there. Thank you. Congratulations.
And congratulations as well to our state runner-up, Gilmour Academy. Congratulations to you.